Welcome to Looking at Legal Stuff. Today we have 6 hearings in a case with a couple where dad has obtained an ex parte restraining order to protect the child from mom's erratic behavior due to a number of recent mental health and substance abuse episodes that have alarmed him, including paranoid and nonsensical texts. Mom claims she just wants to see her child and will do whatever the court wants her to do, but as we return to court time after time, Mom can't even be counted on to turn up regularly and still hasn't paid the guardian ad litem or even communicated with her properly yet, but she always has lots of excuses and continues to beg for visitation. Will the guardian finally get paid and get her investigation done, or will Mom have no input into the new parenting plan? Let's find out.
Going to take number 5, 6, and 7, 19-3-00408-08, Culver and Joplin.
That matters, right?
I'm here, yeah. Terry's here.
But I thought my client might have been present in the courtroom. Jamie, are you here? Go ahead and come up to the table.
So, Ms. Joplin, I did not receive any response from you.
No, I have a meeting with my attorney Thursday, and she was wondering if I could request a continuance from y'all because I wasn't able to acquire my attorney in time because I was having a hard time finding one.
Ms. Bliss?
And Your Honor, I did see that she was just served last Monday. So I think given the short notice, that makes sense. There is a current immediate restraining order in place, so that will need to be extended. I can get you an order extending ex parte this afternoon if that's what Your Honor intends to do.
Okay. So, Ms. Joplin, how far out are you talking about, or?
I have an appointment Thursday with her at 2:30.
So I don't want to set any more on April 9. I think that's going to be a busy day. So I'm looking at April 16.
That works for me.
Ms. Joplin, does that work for you?
I wouldn't be able to see Vinny at all until the 16th or anything until the 16th. I'm sorry.
So at this point, the temporary restraining order was put into place that will remain and be extended. So the only suggestion I can make is talk to the person that you're looking to retain as your attorney and see if something can be worked out in the meantime.
All right. Thank you.
All right.
Thank you, Judge.
Thank you. Going to number 7, 8, 9, and 10. Culver and Joplin matter 19-3-00408-08.
That matters, ready.
All right. So Ms. Bliss, did you receive a copy of the declaration of Ms. Joplin?
I did receive some pleadings from her yesterday and this past Thursday. I've unfortunately had no opportunity to review them with my client, nor obviously prepare any sort of reply declaration, which I, from my brief review, know is probably going to be necessary. So at this point, I'll defer to the court as to how we proceed. I would just note that we were here on March 26th. Ms. Joplin did ask for a continuance at that point to obtain counsel was her representation. We've just received these pleadings within the last day or two. If the court is going to consider her responsive materials, I will be asking for a continuance. Alternatively, I'll ask that we proceed without any consideration of her pleadings and we move forward with my requests.
So, ma'am, there are some very specific rules that talk about deadlines of when things need to occur. I just happened to see this on my desk this morning because it was not timely filed. So can you tell me what happened of why it wasn't?
I first did it, it got sent back to me and I had to redo it all. And I was just I just didn't get it back to you in time. I was trying to get it printed off and it wasn't, timing just didn't work for me on that. And I didn't mean to do the second part. When it got sent back to me, I had to redo it all and I didn't.
Okay. So Ms. Bliss, hearing that, I'm probably inclined to go ahead and give her an opportunity because it sounds like she tried. and understanding that she's pro se and understanding that that can complicate things. What I'll go ahead and do is go ahead and put the restraining order will stay in effect at this point until I have something that I have an opportunity to really read. So I haven't even really read it. I haven't, not when I get it the day of, doesn't work. Okay, I know you did it sometime yesterday, but it didn't get to me until this morning. So the restraining order will stay in place. Problem is that the next three I'll go ahead and put it on May 7th. It'll get set over to May 7th. But what we have are what are called local rules. And there are the rules in there that govern the dates. Okay, so they're on our Superior Court website. You need, if you're going to not be represented by an attorney, you need to know what those timeframes are. I'm giving you a little room here. But you need to understand that, okay?
All right. Is there any way I can just see my kid for a minute at all? Just like a little.
Miss Bliss?
I obviously haven't had the opportunity to speak to my client about that. I don't recall if the current restraining order has any exceptions for telephonic or video conferencing visits. I'm imagining, I can speak with my client, but I'm imagining that could be agreeable pending the next hearing.
So I'm not going to rule on anything at the moment because again, I don't have it really properly before me today. So what I would suggest is just contact Ms. Bliss and talk to her about it. She needs to be able to talk to her attorney, sorry, Ms. Bliss, her client, and see if you can get something worked out. Okay.
Okay.
So, but otherwise I'm going to set this over to May 7th. Ms. Bliss, if you want to go ahead and get me the order extending the restraining order to May 7th, then I'll sign off on that. So the restraining order will be in place until that date. But again, be familiar with those rules. Okay.
Thank you, Judge.
All right, number 3 and 4, 19-3-00408-08 Culver and versus Joplin matter.
That matter's ready, Judge. I believe my client's in the courtroom. Go ahead and come on up, Jamie.
Morning.
I don't know if we have Miss Joplin.
Ms. Joplin, are you present? I do not. All right, counsel, go ahead.
Thank you, Judge. And for the record, Carly Bliss on behalf of James Pulver, moving party in this matter. Before the court today on my client's request for adequate cause and a parenting plan for 7-year-old Vinny. Obviously, I'm imagining the court has had the opportunity to review the files and records. There's some very concerning behavior in mom's home and within mom. My client cites several different concerns regarding potential mental health episodes and or substance use. My client is requesting primary custody of the child, Vincent, at this time. There was an immediate restraining order entered in this matter in March. After Ms. Joplin was admitted to St. John's on an ITA hold where she was there for a week. Since that time, her behavior has continued to be erratic. My client has provided substantial documentation to Your Honor to document this. Recent text messages that were we were unable to ascertain exactly what she was trying to say, but it seemed to be the effect of she was violating the restraining order by walking around outside my client's home, texting him, calling him, trying to make contact with him with a current restraining order in place. Again, obviously, there's some significant concerns regarding her mental health and or substance use. We are asking that she be required to have a mental health evaluation, specifically a psychological evaluation with parental risk assessment. I think that's appropriate given the concerns documented in my client's declaration. We're also asking that she be required to submit to a hair follicle and substance use evaluation. Again, my client indicates there's a history of methamphetamine and pill usage. We're concerned given the statements of Ms. Joplin of people coming through her floor and paranoia of cameras being planted on her property, and that she may have a brain tumor, and then the allegation of her saying, "I didn't try to kill my mom" out of nowhere. There's just a lot of really concerning statements and behaviors of Ms. Joplin, and we're hoping to ascertain what exactly is the root of that cause. My client acknowledges that she has historically been the primary parent of this child. He does not wish to keep this child from her, but clearly there's some significant concerns. We have a young 7-year-old child. He shouldn't have to be exposed to that. And from the looks of it, he has been exposed significantly already. So we are asking for the relief cited in our motion. I would note Ms. Joplin did file some responses. She had shown up historically to these hearings. We've been on the docket for nearly an hour at this point. So given she isn't present today, I would ask that the relief requested in my motion be granted as is.
So in regard to the files and record, I did review it, and I want to note that the mother did file a declaration, which I read too, that was filed on April 15, 24. So although she's not here today, I am considering her filing. And based on that, the court does find adequate cause is appropriate finding. And so adequate cause to modify the current parenting plan. And with that, the court does order a guardian ad litem to be appointed. That would be appropriate. Who would the next guardian ad litem be?
Tyler Corey, Amy Turnbull, and Karen Lawrence.
Ms. Bliss? Okay. Who did you say, Twyla Court?
Yes, Judge. I said I was fine with Ms. Corey.
All right. So what I didn't know for sure is the financial status. I have this at private pay at the moment for 50-50.
That was my request, just given that we have not received any sort of financials from Ms. Joplin. My client does work modest hours. Obviously, now that he has primary custody of Vinny, his work has been reduced. So we are asking, at least at this point, to do private or county pay, 50-50 with reimbursement, obviously dependent on if we get some financials from both parties.
So at this point, I'm going to make it private pay. I understand the situation. At the same time, I'm not sure the court can reconsider that if the financials come back that they simply don't have enough, and then we'll relook at it. But private pay 50-50, and the restraining order shall remain in effect, subject to some residential time for the mother to see the child as proposed by Ms. Bliss's client. The court is concerned about the costs associated with the supervised time and whether mom can do that. Is there anyone else that would be acceptable?
I haven't had the opportunity to speak with my client as to non-professional supervision. If that's the concern of the court, obviously I'll discuss that with my client, and we can attempt to arrange that with Ms. Joplin. I guess if we could just set this either for a review. I don't know if your honor is going to enter the orders that I had prepared for today, or if we're going to have a presentation hearing.
I was going to go ahead and order them today. So at this point, I'll go ahead without her being present. It really makes it difficult as well. So I'll go ahead and order as is, but if it's an issue that comes up, I would like to look at it.
Absolutely.
The psychological evaluation of the mother with input from the father is appropriate. With the parental risk component as part of that. Again, the court's somewhat concerned in regard to the financial cost of those types of evaluations. So it may have to be something that's relooked at again, and maybe the guardian ad litem can weigh in on that. Then when done, copies of the evaluation shall be provided to the father, his attorney, and a copy filed under seal with the court. The mother shall comply with the requirements of the evaluation. Hair follicle test will also be required, and a substance abuse evaluation with input from the father. And the mother is to comply with any recommendations there as well.
And Judge, the only issue I have currently is the orders that I had presented to the court were from, I think, 2 set overs ago. So the dates on the guardian ad litem report, like the 30-day review, for instance, has already passed. That was dated for April 30th. So I would just request new dates on those if you don't have a problem with that.
Can you go ahead and get me a new order
Absolutely.
and go ahead and just put not present for Ms. Joplin? And then put in the
New dates.
new information.
Okay, I can do that, and I'll get that to you for signature today.
Okay. All right, with that, I've signed off on the order on adequate cause to change a parenting custody order. Signed off on the temporary family law order, the parenting plan, and the restraining order. I have not signed off on the order appointing guardian ad litem with a new one coming. All right, that's it.
Very
for that
good. Thank you,
matter.
Judge.
Number 5 on the docket, 19-3-00408-08 Clover and Joplin matter.
That matter's ready.
So we have Ms. Bliss present. We have Ms. Corey present. Do we have Terry Joplin present? No response. Ms. Corey, have the fee been paid and contact made, or where are things at?
Contact has been made with both parties. Mr. Culver has paid in full his portion, and he has also submitted his intake form to me. Ms. Joplin has been another story. She has received twice the intake form. I have not received it back yet and have received no payment from her. She has been in contact via text message that have been difficult to understand. I typically wait until I've received both intakes before I start interviewing parents, just because it gives me better information. But if I don't get that intake back from Ms. Joplin this week, I'll start moving ahead, just interviewing Mr. Culver.
Okay. All right, Ms. Bliss.
I don't have anything further to add. I would just ask that Ms. Corey does begin her investigation if she hasn't made contact. As the court's aware, Ms. Joplin has been hard to get a hold of and get to engage and participate in this action. So I would hate to prolong a final report based on her lack of participation.
So the only thing I can suggest, Ms. Corey, is maybe let Ms. Joplin know that if she doesn't respond, doesn't provide information, that it's going to end up being all based on Mr. Culver, and maybe that will, and basically, like, and maybe you've done this, maybe that she make sure to submit her information so it can be, as you said, have all the information. Try that if you haven't already, and or at least try one more time, and if not, go for the one-sided. I don't know what else to do.
Yeah, thank you.
All right, thank you.
Thank you, Judge.
Okay, not hearing any. I'm going to start with number 1 on the docket, 19-3-00408-08, the Culver and Joplin matter.
That matter is ready. Curly Bliss on behalf of Jamie Culver.
Anyone else present?
Yeah, Terry, hi.
Twyla Corey, guardian ad litem.
All right, so this is cause number 19-3-00408-08. And when I looked in here, and I don't know if I was just I don't believe I was missing it, but is there any report that's been filed?
There is not, Your Honor. When the interim report was assigned, the court indicated that it was okay to do a verbal interim with a email to the attorney beforehand, which I did do.
And I did receive that.
So generally that also goes to the judge. Did you send it to me as well?
So I was unclear. We've kind of been told that we shouldn't send things directly to the judges, and I honestly did not know what to do with it. If you could clarify, that would be appreciated.
We need, I want to see something in writing. So it's going to be by email. Then as long as you are sending to all the parties as well as the judge, you should be okay on sending a report. The other option is to do a quick type it up and file it with the court and do a bench copy. That works as well. What they're talking about that you shouldn't send things to the judges is we can't have ex parte contact. So as far as the idea of just sending things without copying the parties. We don't, email isn't the best way of doing things at times, but when it comes to something like this, yes, because I haven't read it, I don't have a clue what it says, so
Okay.
assume there wasn't any report.
So Judge, if you don't mind, if we want to set this matter over, that way Your Honor has the opportunity to review, I can just note my review of Ms. Corey's interim report. She didn't recommend any changes and there wasn't a whole lot to report. I can obviously let her speak to that, but I believe that she just recently had contact with mom. It might make some sense to set this matter over so she can continue to have some contact with mom and see what the likelihood of getting that final report entered in on time, and maybe we can address that at a future hearing as well.
Okay. All right, Ms. Joplin, or does that sound okay to you?
Yeah, it does. I just really want to see my little one. So whatever we can do, I would just like to do it so I can see them.
Okay. So I think, you know, if that's essentially, Ms. Corey, if that's what you're saying is that it's essentially not recommending anything as any changes as Ms. Bliss has indicated, then we could go ahead and set it over to the 30th. And would that be enough time, or we could set it over further?
And Your Honor, I'm actually scheduled to be out of the office on the 30th, so I would request the 6th if we're going to set it over.
All right, so
I don't want to send anything over. Why do we have to send? We can't. Like, why do we have to keep sending and pushing everything off so much?
Joplin, I'm having a hard time understanding what you're saying.
Sorry. Cool.
Go ahead and repeat.
Can you hear me now?
Yeah.
There you go.
How come we have to keep putting everything over and we can't just kind of like get it on, like all the good fun all done with? Because I don't want to push this off anymore. I really want to see Vincent more than anything, and I just don't want to keep just pushing it off.
Well, I understand you may not like continuances, and I get that you want what you're wanting to see. At the same time, it takes time. And at this point, one, I didn't receive the report, so that's an issue. Secondly, my understanding is the report is recommending no real change at this point. So that's the second thing. And so this is for looking at it further to see how much time Ms. Corey, and correct me if I'm wrong, Ms. Corey, this is to, so you have more time to talk to Ms. Joplin, is that correct?
Well, thus far, Ms. Joplin has not been very cooperative. I have not received payment, and I just Friday received her completed intake that she's had for well over a month. And if she's not cooperating with me, I can't move any faster.
So
I wasn't trying to be uncooperative. There was a lot of different issues with the paperwork.
Joplin, stop for a minute, please.
I'm sorry.
Your Honor.
Hold on, please, for just 1 second.
Apologies.
Oh, sorry, was that you? Oh, okay. All right. All right. So anyhow, so bottom line, I am going to set it over. Ms. Joplin, you need to be timely. One, you need to make your payment. It's a court-ordered payment that you need to make. So you need to get it paid to Ms. Corey right away. Secondly, when she reaches out to you, you need to respond and you need to do it quickly, not you're not wanting to continue the case and you just want what you're wanting. But there's a process that needs to occur. And so it's going to take time. But I need to be responsive. So with that, I'm looking at August 6th.
That works for me, Judge.
Ms. Joplin, does that work for you for a date?
Preferably not, but I will do what I got to do. And I have a question on what kind of evidence did James present to show that he needed a restraining order on me? Because I don't know.
I'm not even going to go there. The only question right now is whether or not August 6th works.
Okay, yeah.
Okay, Ms. Corey, does that work for you?
It does.
So I'm going to set this matter over to August 6th. And Ms. Joplin, when Ms. Corey contacts you, reach out, but get that payment to her right away.
Yeah, for sure. But I still would like to know how to find out what evidence he presented to show the restraining order stuff. Because I don't know what it was. And I'm confused on how he was able to get that on me when I'm not doing anything.
Maybe you need to reach out to Ms. Bliss, but I'm not going to take the time right now to go.
All right, cool. She says she won't talk to me, but that's fine.
Ms. Joplin, call my office after court today. I'd be happy to speak with you.
All right, thank you.
Thank you. Thanks, Judge.
Next, I have James Culver and Terry Joplin, cause 19-3-40808. There, Ms. Bliss is representing James Culver, and Ms. Bliss is present.
Yes,
and
Judge.
then Terry Joplin, are you on the line today, Terry Joplin?
I am. Hi.
Okay, welcome to you, Ms. Joplin. And Ms. Corey is the guardian ad litem, and she's here. I can see her. Ms. Corey, can you hear me all right?
I can, thank you.
Perfect. All right, today was set for interim GAL review and the report that has been submitted. I reviewed that, and I'll just hear if Ms. Corey, if you have any additional comments other than your report, and then we'll hear from Ms. Bliss and then Ms. Joplin.
I do not have any further comments other than I would like to be in touch with Ms. Joplin to have her included in this report. It has been difficult communicating with her.
Okay. All right, and then Ms. Joplin, do you have Ms. Corey's contact information?
I do, and I've been emailing her and I texted her many times, and she said that I wasn't complying with her, and that's not very true. I more or less just ain't complying with the whole I can't pay part because I can't pay. And I thought they weren't allowed to start their investigation until both parties paid. So I'm a little confused on that one.
Yeah, not necessarily. I mean, the idea is that the court appoints a guardian ad litem to do some investigation, and the court doesn't necessarily want to be hamstrung by parties either with parties not complying and maybe dragging their feet. Not to say that that's what's happening with you, but sometimes that happens, and so guardians are ad litem are given their charge, and sometimes they need to move forward with or without the person's input. And so if people want to participate, then we wholly support that. And we want people to participate and share their information, because that's the more information that we have, the better. So the greater involvement any litigant or party can have with the guardian ad litem and sharing their information and perspective, that gives a robustness to the report. So we'd encourage that further involvement and input. So if you maybe haven't had the full circle hasn't been made as far as sharing your input, I'd certainly encourage you to continue to reach out to Ms. Corey and share that information in timely ways.
Yeah, yeah, of course. I wrote her on the 23rd or the 22nd, one of the two, and she said that she was on vacation, and so I waited, and then I never heard back from her. And when I finally did write her again the other day, that's when I got her Gale intake, and I thought that was not very fair. I mean, I'm trying my best doing it on my own and not knowing what I'm doing. So
Okay. Yeah, with investigations, having the information earlier rather than later is definitely helpful as a guardian ad litem investigates cases. Sometimes they will talk to people 2 months ago or 3 months ago, and then the report comes out later. And so when information comes late in the game, sometimes it just can't, it's just not feasible to get that information in a timely fashion. So thank you for that input. Ms. Bliss, do you have any input at this point?
I don't, Judge. I did receive the interim report. In her report and recommendations, she requested no changes. My client's comfortable with that. We believe our parenting plan has sufficient safeguards in place for this child, and to hopefully get Ms. Joplin back on her feet and in a good space for her child. I did note that the final report is due on the 13th. I don't know, given the delays that we've had thus far with cooperation and whatnot, I don't know if that's still feasible. So I would just bring that to the attention of the court and Ms. Corey.
Yeah, thank you. So looking at that order appointing the guardian ad litem, that does have those dates laid out of the 20th of August is the next report. So this report, the interim report, is a little bit delayed from the anticipated date of July 16th and due to different factors. So we're about 2-3 weeks from that. And so we might want to look at pushing out that final report date 2-3 weeks. Ms. Corey?
Your Honor, I have requested records from DCYF, and they've indicated that those will be to me by the 17th of September. So
okay.
If we could go out after that date, that would be appreciated, so that I could have all of those records available.
Yeah, generally, how are they pretty good in keeping their estimates as far as?
Yeah, if they put it in writing, it's most
Pretty
likely going to happen. So,
okay. And then turnaround time for them if you receive them on the 17th, 2 weeks.
2 weeks would be great.
That would put it to October 1 for the due date. Ms. Bliss, any comment on that?
October 1st works for me, Judge.
Okay. And then Ms. Joplin, any comment on the October 1 review date, basically for that order to be reviewed, or pardon me, the final GAL report to be reviewed?
no, that's fine.
Okay. Well, let's go ahead and then we'll change the final GAL report review, striking August 20th and moving it to October 1st. And then I appreciate you being on the call today, Ms. Joplin. And then it sounds like you've been in contact recently with Ms. Corey, and just encourage that to continue, and that'll allow for your voice to be fully heard, and earlier the better as far as contacting. So, staying in good contact now will allow Ms. Corey to take into account your information and then have that report issued on October 1.
Also, I'm sorry. Also, Your Honor, If, how might Ms. Joplin ask for the county to pay the GAL fee in this case?
Yeah, that's a very good question. So there was an order appointing, and that order appointing, let me just get to the point, the portion that it talks about payment. So under section 10, it says that it's a private pay, that 50% will be paid by petitioner, 50% be paid by the respondent. If your situation, Ms. Joplin, has changed in that you're not in a position to afford that or the like, you could submit a very simple motion in paper format to the clerk and say, hey, Judge, I'm not in a position to do that. I don't have a job. Or you can kind of explain your financial situation, say, I would like the county to pay for that. So if that's something that's holding you up as far as making payment because financially it's just not possible to pay that, then you could bring a motion to basically change that order that said you have to pay 50%. And if it's granted, then the county would cover your portion. Does that make sense, Ms. Joplin?
Yeah, I had the paper once filed out and I couldn't figure out how to, yes, I understand, yes.
Okay. And if you have any questions with that, you could check with the clerk's office, and you even might even could check with Ms. Corey, and she might be able to give some helpful insight and the like. And then that would certainly help the process move along more smoothly if that order or if that motion was granted.
Okay.
Thanks, Ms. Corey, for raising that. Ms. Bliss, any additional items you have?
Nothing from me, Judge.
Ms. Joplin, do you have any additional items for today?
I just want to see my son over a meeting or anything. I took the evaluations and I'm doing the mental health things that James is insisting I'm doing. So, I just want to see Vinny a little bit, anything.
Yeah, that's fantastic. Good to hear that you're getting involved with those different services. I appreciate that. So right now, the parenting plan that was entered on May 7th. So it looks like the visitation at this point is supervised and can be up to 2 hours per week. So check with, there's a group called Cowlitz Family Advocacy, and that's who you can. Nope, Ms. Corey's saying no. Go ahead.
It's called Reconnecting Families.
Yes.
Oh, okay. Reconnecting families is who you'd need to contact. And if Ms. Joplin, if you don't have that phone number, you could probably look it up online, or maybe Ms. Corey could assist you with that phone number. And then that would allow you to have some contact with your child.
Okay, thank you.
All right. Thanks. So we'll see everybody October 1, 9 a.m.
Thank you, Judge.
Great, thanks.